If you don't have an attendee ID, please press pound. There are 43 participants on the call, including you. You are joining your conference as a participant. For a menu of available commands, press *#.
Suzanne, you there? Now I don't hear you.
Did you hear me before?
No, but now we hear you.
You can hear. All right. Can you hear me now?
Yes. Perfect.
Do I sound clear enough?
Yep.
Okay. All right. Let's just go back to the rules and frustrations for the day. Okay. So today we're going to talk about data, do a little introduction about what we mean by data. We're going to talk about the statutory provisions that apply to advocates and their programs and your ability to access data. And at the end, we'll just talk about summary data. By that, we meaning how do you get information about the incidence of crime in your community, to get summary statistics about arrests, convictions, those type of things. All right, first, when we're talking about data, what do we mean by data? The title was Data Basics for Victim Advocates, but we mean a lot of different things by the word data. We could be talking about the information about a victim that you have or that somebody else has that they want to get about the victim. We could talk about the data that gets generated with an investigation, charging decisions, the outcome of a case, post-conviction, or we can talk about that summary data, about the incidence of victimization, where we're looking at overall the law enforcement response in your community or in your state or across the country, crime rates and criminal charges is the kind of data that we might be interested in as well. Why do we have a data presentation? The bottom line is because most of you on the line, your program has to comply with the Minnesota Government Data Practices Act. That is most likely applying to your organization in some way, and that's what we're going to be talking about today. Also because advocates are frequently trying to get data themselves to do their jobs. Also because there's a lot of people trying to get the data that you have, and so you're trying to prevent others from getting the data that you have about your victims, so you're preventing that from being revealed. And really, data questions are an everyday occurrence in our work. So the goals of this presentation is that you get a basic understanding of the Minnesota Government Data Practices Act, the statutory protections and privileges that exist, the provisions that allow victims and advocates to get data, particularly police reports, and that available summary data that we have. What's available and really what's not available is probably the biggest question. So before we begin, I wanted to just kind of point out something about data and confidentiality. This is not a presentation of how you keep confidentiality. Instead, it's a presentation about why you have to keep confidentiality, the source of that confidentiality requirements, which is going to be statutory, contractual, and ethical. And when we say ethical, we're talking about things like an attorney's ethical obligations to keep confidences, for those professional ethics with attorneys and therapists and counselors, social workers who have their ethical obligations. But we're also going to be talking about the statutory rules that apply and your obligations to comply with that, and the contractual obligations you have to comply with certain data practices. First, let's head right into the statutory provisions. The first, the big law in Minnesota is the Minnesota Government Data Practices Act. By the end of this presentation, that should just roll off your tongue, or maybe not. Most people just refer to this as Chapter 13 or the Data Practices Act. And what the Data Practices Act is, what it does is it sets out the rules. The rules about how we classify data, what those classifications are for certain data, how those classifications impact who has access to the data, how to request data, and what happens if a government entity won't give you the data that's been requested. So those are the set of rules that we have to live by. But the biggest rule and the place that we start is the basic presumption in Minnesota, which is that all data is presumed to be public unless specifically classified otherwise by state or federal law. We assume everything's public, and then we start talking about the exceptions for why it is not public. So here's our first here are the primary classifications under the Data Practices Act. We have public, private, confidential, non-public, protected non-public, and I've defined them here with the statutes. but I really wanted to just focus on the ones that you most likely will be dealing with, which are these three classifications. It's either public, which means that it could be public on an individual, business, or other entity, and anyone can access that public data. It can be private, and that's we're talking about individual data, and the access to that data is limited to the subject of the data or the subject, others who the subject has consented to have the data, or it could be confidential on that individual, which means no one besides that government entity that has it can see it. So public, we all get to see it regardless of our status. Private, only the subject of the data, and confidential, no one gets to see it. So how does this apply to your programs? Well, we have to look to the statute, Minnesota Statute 1305, which says if a government entity enters into a contract with a private person to perform any of its functions, then all the data created, collected, received, stored, blah, 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 is private, disseminated by the private person in performing those functions is subject to the requirements of this chapter, and the private person must comply with those requirements as if it were a government entity. So even though it says private person, we're talking about outside entities that are contracting with state government or city government. So a contract could include a grant agreement. That's an agreement between, for example, Office of Justice Programs and a grantee. That's a contract. That's an agreement saying you promised to do this in return for getting the money from OJP. So all of you grantees are under a contract and must comply with this law. That was made clear in a situation that happened in 2009 where there was a domestic violence program that was receiving grant funding from a city government entity, and an administrative opinion from the Department of Administration, they issued an advisory opinion which made it clear that that DV program, this community-based nonprofit DV program that received grant funding from the city, was required, came under the Minnesota Government Data Practices Act, and as a result was required to comply with a data request related to its operations. And that some of the things that they asked for were their volunteer manual and who's on their volunteer list and those types of things. So because of that case, in 2010, a new law was enacted. Thank you, Minnesota Coalition for Battered Women, for pushing this through. This law says that community-based domestic violence and sexual assault programs are exempted from Chapter 13, the Data Practices Act, except they must comply with certain sections, and they're listed here on this slide, 1382, and then 3 provisions under Chapter 611A. What that means is that for some purposes, the Chapter 13 does apply, and primarily in terms of how we define data. So let's look to those 611A provisions. There are 3 primary provisions that you as grantees can look to protect the data that you have within your organization. The first one is data protection that applies to all crime victims. So that's Chapter Minnesota Statute 611A.46, and that says all that personal history data and other information collected, used, and maintained by OJP grantees from which the identity and location of any crime victim may be determined are private data. So that's, regardless of crime type, this is protecting your crime data or victim data that you have. Again, it's only for OJP grantees. And this also under 611A.46, the Office of Justice Programs itself has a data protection as well. And that says that if we get victim data, and that could be we get victim data, say, from grantees related to an emergency fund request or related to reparations or different things, if we have victim data within our office for our operations because of the jobs that we do, that also is private data, and we must maintain that data in accordance with Chapter 13. So the next 611A protection is related just to domestic abuse victims. So those grantees, OJP grantees who get domestic abuse funding, they come under 611A.32, and it says personal history information and other information collected, used, maintained by the grantee for which the identity or location of any victim of domestic abuse may be determined is private data on the individuals, and you must keep that data private. So this dictates just for those domestic abuse program grantees. That's your protection that you have. And then finally, we have another one that's just for domestic abuse victims in shelter programs. 611A.371, same type of language, information maintained by a designated shelter facility for which the identity and location of the battered woman may be determined. Again, private data, again, OJP grantee, those OJP grantees who are getting shelter funding. So we have those three data protections. In addition, there's additional sexual assault protection. So again, this was the statutory exemption that I rattled off saying, you know, this is how DV and SA programs are exempted from Chapter 13. However, they all must still comply with that list of statutes. I've highlighted the ones that refer to sexual assault, and that's 13.822 and 611A.46. So let's look at the first one. This is a data protection for sexual assault victims, and it applies to communications between a sexual assault victim and a sexual assault counselor. So this is communication data that we're talking about. So this is under Chapter 13, and it says this information, this communication data, is classified as private data on individuals. So those of you working in sexual assault programs have this additional protection about your communications has a data classification of private. In addition to that one I mentioned before, 611A.46, which applies to all grantees serving crime victims. So again, these are only applying to community-based programs, and this one in particular is 1382 is community-based programs providing sexual assault services, and only to those that are considered crisis centers, which means those organizations whose primary purpose is to provide assistance and referral to sexual assault victims. Questions on that? I'm going to pause for a minute because I know I'm talking fast. All right. So just to review, we have our Data Practices Act, Chapter 13, which defines private data, and we have the three provisions under Chapter 611A. And remember, Chapter 611A is our Crime Victim Bill of Rights is in there. It's all the crime victim-related legislation is in 611A. So our three data protections for crime victims are located in Chapter 611A, and they cross-reference the Data Practices Act, Chapter 13. So they say we've got private data as defined by Chapter 13. So why is this data classification important? Again, because the classification of private data means that any program or advocate cannot release that data to anyone without consent of the subject of the data, the victim, or by court order. Now this came up, and I said I wasn't going to talk about how you maintain your confidentiality, but this slide reminds me of a conversation I had this past week where the issue is, what do you do when there is the deputy sheriff at the door saying, I want to do a welfare check and talk to that person that I think is in your shelter? Well, this is what you invoke. You've got information about this victim, and it's private data, and you're not supposed to share it with anyone without the consent of that victim or court order. So that's where you start. That's why knowing the statutes is important. So a lot of times we hear this conversation about, well, I'm supposed to do this because of VOCA and VAWA. So let's talk a little bit about how they actually come into play. VOCA and VAWA, Violence Against Women Act, and the Victims of Crime Act, both have requirements about the need for grantees to adhere to the confidentiality requirements. So if you're going to get grant funds under VAWA or VOCA, then you must comply with the confidentiality requirements. So VOCA and VAWA money flows to Minnesota, or goes to Minnesota, and it flows through Office of Justice programs to your programs. Now the state, when we do our OJP grant agreements, those contracts say, as a condition of you getting this grant funds, you agree to comply with the VAWA and VOCA confidentiality requirements. So in addition to all those state requirements that we've been talking about, when you become a grantee and you enter that contract, you also have promised as part of that contract to comply with these federal requirements under VOCA and VAWA. Also, as part of your contract, it says you're complying with the state requirements. So that contract addresses both your state requirements, data protections, and your federal requirements for data protection, confidentiality requirements. I think I put this up here too because I had a conversation, the same conversation, with a criminal justice professional who says, well, I don't care what VAWA says because that really doesn't apply to us, you know, and so you think, let's go back and figure out how does it apply to our programs and how it applies in addition to state law. And in this particular case, that criminal justice professional was concerned about state law as opposed to the VAWA requirements. And once we started talking about state law, then it became a little bit clearer for that person to figure out how they're supposed, what that conversation was about. Okay, let's look. So far we've talked a lot about protections that mostly apply to community-based programs. But when you look at chapter or section 611A.46, that one that I said, if you're a grantee that provides services to crime victims, this is the data practice provision that applies to you. That one is not restricted to a community-based program or a government-based program. It applies to all the OJP grantees. So that section applies to a government, an advocate within a government setting. Any advocate within a government setting is part of a government entity, which means Chapter 13 in its entirety is going to apply to that program within the government entity. But we can look at protections under 611A to protect that victim data, even if it's in a government entity. So just like any other grantee, a government-based advocate must comply with the contractual requirements under OJP, both federal and state. And keeping in mind that those folks working in government-based programs might have different situations where you don't have the same kind of insular organization that you would if you're a community-based program. If you're in a prosecutor's office, there are no walls between that advocate and that prosecutor. Now, you might not talk to the prosecutor about every single thing that the advocate or that a victim might tell you, but in terms of what that victim tells you, you have to regard that whatever the advocate knows in that office, the prosecutor knows in that office. There are no walls or barriers between an advocate or their supervisor within that governmental office. That being said, there might be additional obligations on an advocate who is, say, working in a prosecutor's office who must follow the ethical obligations of a prosecutor, including disclosure under exculpatory information and Brady disclosure rules. That's all for a different lecture. But the advocate in that government-based advocate might have those additional concerns and ways that they have to operate that are different than a community-based program. Pausing for any questions there. All right, we'll move on. Let's talk about law enforcement data. And it's a biggie because what people are asking our office, Crime Victim Justice Unit, all the time is, how do I get a copy of my police report? Advocates are always asking about trying to get copies of police reports, domestic abuse events within their community. And so it's a big issue. So let's go through and talk about some of the basics of law enforcement data. And all of these provisions are found under Section 1382, again within Chapter 13, Data Practices Act. This is law enforcement data and has all the different classifications or different types of law enforcement data that exist, and that the data classifications on those individual types of data. First one, request for services. Somebody asks for help from the police, that's public data. There's certain exceptions about what information we can suppress, but in general, somebody calls for help to a house because of a burglary, that's going to be public data. If somebody makes a 911 call, the transcript of that 911 call is public, but the audio recording is not public. If the law enforcement officer comes to the scene, responds to that call, that response data is also public. And when we talk about response data, within Chapter 1382, Subdivision 6, there's a whole list of things that would be included in that response data. Basic information about what happened, where it happened, who's involved, how did they get here, the general type of call it was. There's a list of things that are considered response data that would be public. If we wanted to get the public portion of a police report, that's generally what we're going to see in this response incident data. That's what you're going to see, that list of information. If somebody's arrested, that's public information, and there's certain list of things that you get, a person can get about an arrest, you know, whether there was any violence in trying to apprehend that person, the circumstances of the arrest, who was arrested, their age, where they got brought, all those things, that's public data. So we don't have secret arrests or elsewhere. Similarly, if somebody's in jail, that's public. We get to know the fact that they're in jail and where they are in jail. That's all public data. If somebody's booked into jail, we get to see the booking photos. That's public data. Then let's get to the tough one, investigative data, criminal investigative data. Is that public or not public? Well, that depends on where we are in the case. If the case is under investigation and it's considered an active investigation, that's the language of the statute, in an active investigation, that data is considered confidential. If it's inactive, the investigation is inactive, then it's classified as public. So as long as that case is under investigation, nobody can see it. So remember we had those three classifications: public, private, confidential. Public, anybody can see it. Confidential, nobody gets to see it except for the criminal justice entity that has it. And we're going to talk about that in more detail in just a moment. And then finally, photos, which are part of the investigative file. This comes up occasionally in our office. After an investigation is inactive, so our investigation's done, it's classified as inactive, photographs in general will be public, except there's a provision within 1382 sub 7 that says photographs which are clearly offensive to common sensibilities are classified as private or non-public. And it's under that provision that, generally speaking, they will suppress the distribution of crime scene photos, especially but that private, we're talking private to the individual, that doesn't mean that the person who's the subject of the data can't get it. So in the example of a deceased victim, in general, that's not going to be released to the public, but if I was the next of kin and I wanted those crime scene photos and I actually wanted to see them, I mean, that may or may not be a good idea. That's a different discussion. But do I have a right to see them and get a copy of them under the Data Practices Act? And the answer is yes. When a person, subject of the data, is deceased, then the next of kin can act in their stead under certain circumstances, and this is one of them, that I can assert the right of the subject of the data and ask for copies of those crime scene photos. And again, whether that's a good idea and how that might happen, that's a whole different conversation, but they do have a right. All right. So I talked about, once a case is criminal investigative data, once the case is inactive, everything's public. In general, we presume certain things are public, but there's some exceptions in 1382, some that are automatic and some that can be invoked, that there might be some law enforcement discretion in invoking them, or there might be some steps that a victim has to take to invoke them. So under section 13.82, subdivision 17, there's a whole long list of things that say we're not going to release these certain things under certain circumstances. So, for example, you have a confidential informant, that doesn't get released. You have a situation where somebody reported a mental health crisis, that's not going to get released. So different things are in that list, but the ones that are more common, the ones that you will run into the most, I'm going to discuss here. The first one is that a victim, and I'll talk about this as a victim right, a victim has a right, and witnesses have a right to request that their identifying information be withheld from the public in a law enforcement report. So once that report becomes public and anyone can see it, before that happens, a victim can go to the police station and say, I want to withhold my identifying information from public view. Is that automatic? No. The law enforcement agency has discretion to withhold it or not. So they can withhold it unless they reasonably reasonably determine that the revealing the identity of the victim or witness would not threaten the person's safety or property. So, for example, if I wanted to report that somebody stole all the pots off my patio and stole my tomato plants, and I reported that to the police, and I said I want my name withheld, am I at risk of harm? Is there a security issue, a personal safety or property issue? Probably not. But if I witnessed a drive-by shooting involving rival gang members and I asked that my name be withheld from public distribution, well, yes, probably that would be something where you can say revealing the identity of me might pose a risk to me. Second, juvenile witnesses. And I've had a couple of questions about this over the years about whether or not law enforcement should automatically withhold the identity of juvenile witnesses. And that could be juvenile victims as well. And there's a whole other thing about victims, but just a juvenile witness, it's not an automatic that there's nothing that says automatically juvenile witnesses, their name should be withheld from public distribution. Instead, it says data is withheld if the agency reasonably determines that the subject matter of the investigation justifies protecting the identity of the witness. So again, looking at a simple example of the juvenile witness, if my son, the juvenile, reports that the tomato plants were taken off my patio and reports that to the police, should that be withheld? Probably not. There's nothing really to justify protecting the identity of my juvenile son witness. But you can easily see that there might be other circumstances where you'd want to protect that juvenile witness, and especially as we start talking about younger children. All right, here's some automatic withhold. So again, they've got the situation where the investigative report is now public and is going to be released with certain exceptions. Here's the basic exception that the identity of a victim or alleged victim of criminal sexual conduct or child porn and use in sexual performance, those victims, their names and identifying information will automatically be withheld. The law enforcement agency does not have discretion. It's automatic. Similarly, the victims of vulnerable adult maltreatment and child abuse and neglect, their names are automatically withheld from public distribution. There is no discretion on the part of law enforcement. They must redact. So when we talk about getting a police report, and probably most of you have seen the handout that the Crime Victim Justice Unit has saying, how do I get a copy of my police report? And we prepared that because we used to get those questions, and we still do get those questions all the time. But what we hear is, one, how do I get a copy of my report? But also, why won't they give me a copy of my report? Or I asked the investigator to give me a copy of the police report, and he never did. And when we look at this request about getting a police report, there are two things going on. One is a process issue about how you request, and the other one is a timing issue about when that request is made. So let's look first at that process issue and some advice that we give to victims. The first is never ever ask an officer, sergeant, detective, investigator, or chief for a copy of the police report. I hear this all the time, just a common refrain. The victim will be calling me and they'll be complaining about a lot of different things, and then they'll always say at the end, not always, but overgeneralizing, but frequently will say at the end, and not only that, I asked the chief for a copy of the report, and he never gave me one. Or I asked the officer for a copy of the report, and he said, yeah, you'll get one, and they never gave me one. And what that officer, sergeant, detective, investigator, or chief, what they should be saying is, if the victim asks for a report, they should say, yes, you can get a report when the time comes and it's available, and here's how you do it. Here's our process in our agency to get a copy of your report. And that's the gap that we often see in the frustration with victims is nobody's telling them, don't ask these guys, you're going to ask and find out what that process is within that department to ask for that police report, because otherwise you might get frustrated when you don't get it. And so that's something that you as victim educators can make sure that you pass that information along about how to ask for that report. The other thing is about doing a little research before tracing down to the police department to get a copy. So first, always encourage your victims to look at the website, or if you know the process within your community, you'll be doing this yourself. Always look at the agency's website for information about that process, about how to request, who knows? In that department, it could be that you can only ask on Tuesday, Wednesdays, and Thursdays between 9 and 4. You know, you want to make sure that if there's some procedure already posted, that you're familiar with the procedure. It's okay to call ahead and ask, you know, I'm going to be asking for this report. Can you give me an estimate of how much it's going to cost so that I make sure I bring enough money? Ask what form of payment is okay. They might only take a check or cash and not credit card. They can ask if there's any electronic files and ask the question, well, how much is that going to cost? What's the additional fee for getting a CD that has the interviews or has the photographs on it? And how long is that going to take? And so the victim can decide if they want to pay for the interviews or photographs. By asking this question also, you're prompting them to ask to see if they even exist. Because it's very common for a victim to go to the police department and say, I want a copy of the report, and you get the paper. But what they don't get are all the audio tapes of the interviews. They don't get the photographs or anything else that might be in electronic media, and they don't even know that exists necessarily unless they can figure it out by getting the report or somebody says it exists. So before walking down there, ask the question, are there electronic files associated with this police report, incident report, and what are they? And then you can make a decision, or that victim can make a decision about whether they want to pay for getting copies of that electronic media. Always good to find out, where do I go? Sometimes it's very confusing, and especially when you have a large multi-precinct department, there might just be one place that you go, and that's the main headquarters, say in Minneapolis. You don't go to precinct 4, you go downtown and you go to the main office, and that's to the records department, and that's where you have to get a police report. Know where it is in your jurisdiction where you should be sending victims. And then also, it's always good to call ahead of time to make sure that you know where you are in the investigation, to know if you can even get the police report at that time. So I had a victim of a pretty serious crime who was really upset with the police department because he talked to the investigator, and he had asked, can I get a copy of the police report? And the investigator said, yeah, you'll be able to get a copy. Yeah, you'll get a report. And the investigator didn't say, well, not yet, though, because right now the investigation is, you know, the case is still under investigation. But the investigator said, yeah, you'll get one. And then the victim kept calling the investigator back and calling the investigator back, saying, when am I going to get that report? When am I going to get that report? The investigator doesn't call him back. The victim's getting frustrated. He goes and starts to escalate it, goes chain of command, finally figures out by talking to somebody higher up, oh, yeah, you're supposed to go to the records department to get the report. That's where you can get the report. So he goes, takes time off, drives downtown, goes to the records office, and says, I want to get a copy of my report. And he finds out, oh, you don't get it right. You can't get it right now because the investigation is still active and the data is confidential, and so you can't get it. So we had this guy going through 2 weeks of frustration only to find out at the very end he still couldn't get it because it was still under investigation. And he says to me, if somebody had just told me in that first phone call what the process was, I wouldn't have been so frustrated and upset with the police department. This could have gone down such a different road, but because of the way this transpired and the lack of information about the process, it was extremely frustrating for him. So let's talk about that timing issue. Requesting the police report. So I put police report in quotes because that's the shorthand way of phrasing the investigative report or the incident report or whatever they might be calling it in your jurisdiction. But we're talking about the result of the investigation. The written report and attachments, electronic attachments, constitute the report. Everything, not just what's in writing, but pictures and electronic media of any kind, that's the report. And what we're really talking about is law enforcement criminal investigative data, and that's defined under 1382 sub 7, criminal investigative data. So when you can get law enforcement criminal investigative data depends on where you are in the process. And here on this slide are just the phases of the process. And okay. Got a question, but I'm going to I'll finish this and I'll look at that question because I think it's coming up in the next slide. So first off, when that case is under investigation, when it's an active investigation, that is confidential data. Nobody gets to see it. So from the time of the incident through investigation, that investigation is active, so we have confidential data. Nobody gets it. If that case gets investigated and it goes to the prosecutor, prosecutor reviews it and declines to file charges. Once the prosecutor has declined to file charges, all of a sudden that investigation is inactive. Once it's inactive, now we have public data, and that criminal investigative file is public with those exceptions that we talked about. So let's say the prosecutor decides to file charges, and now the case is being prosecuted. During the time that the case is being prosecuted, through the prosecution phase to conviction and through the appeal phase, during that whole phase, that investigation is still considered active. And because it's still considered active, that data, that report that we've been talking about, remains confidential through the entire phase. So here's an example. This case, you could have cases pending for a really long time considering staying active where that data is confidential. An example of that is the Jacob Wetterling kidnapping and murder. That case lasted for 27 years. That data is confidential up until the case was resolved and through the appeal period, and now after that appeal period is done, that data is going to be considered active with those exceptions that we talked about. Well, even while the case is, or while the case is under investigation, the investigation's active, even during that time, there is an avenue for the victim to make a request for that police report, that shorthand phrasing, police report. And it comes under 1382 subdivision 13, which says that a victim of a crime can make a written request to the prosecutor to release this investigative data collected by the law enforcement agency or to the victim's legal representative. And the prosecutors, you know, when you look at this language, it says the prosecutor shall release this investigative data unless the prosecuting authority reasonably believes, A, that the release of the data will interfere with the investigation, or B, that the request is prompted by a desire on the part of the requester to engage in unlawful activities, do bad things, take revenge, for example. So it does say that the prosecutors shall release this, but in our experience, we have different approaches to this statute by prosecutors. There are some jurisdictions who look at this and say, yep, you can have it while the case is still being prosecuted, and we'll turn over a law enforcement investigative file. I've heard that a lot. There are other prosecutors' offices who will take the firm stance that any release will interfere with an investigation, and so they will never, ever release a police report to the victim prior to the resolution of the case. So know how it works in your jurisdiction to see what you can advise your victims. All right, let's move on to a big thorny issue, and that has to do with a victim and advocate's access to a law enforcement report for domestic abuse victims. There are two statutory provisions that allow for a victim of domestic abuse or their advocate to get a copy of the report, I'm putting that in quotes because I'm going to explain that, for free. So the first is this provision 629.341. This is the one about warrantless. You know, there's all sorts of provisions related to domestic abuse in this section dealing with warrantless misdemeanor arrests and things like that. But there is one provision that directs law enforcement agencies to write a report. You know, this was written back in the days when you have lots of law enforcement responses and no reports written. And this is saying you got a domestic abuse case, you are supposed to write a report. And this says, you know, the copy of this report must be provided upon request at no cost to the victim of domestic abuse, the victim's attorney, or organizations designated by the Office of Justice Programs, victim-serving organizations, domestic abuse victim-serving organizations. So we have to have a report that's written, and that report is supposed to go to the victim or their advocate at no cost upon request. So that's one place where you'll see this provision. And the second place you'll see it is in actually Chapter 13 under Law Enforcement Data, Subdivision 5. It's cross-referencing that statute I just talked about, and it's saying the same language. You get to get a victim or their advocate gets a copy of that report upon request at no cost. So these are the two things that you rely on when you try to get a copy of domestic abuse reports from your local law enforcement agencies. But anybody who's been in the domestic abuse field knows that that is easier said than done. So just a couple things about that. First, if you are not designated and want to be designated, the way to get designated is to request that through the OJP, and their forms are located on the OJP website under the grant tab. And it's the grants unit, Cecilia Miller in particular, is the one that designates programs under the criteria that they have. And the list of designated programs that have been designated by OJP are also listed on that website. But what we know about these two provisions is that practices vary greatly across the state. We have different arrangements between programs and law enforcement agencies. We have different methods of requesting reports, different methods of receiving reports, different interpretation of what constitutes a report under that statute, different levels of cooperation between programs and their local law enforcement agencies. This is a really big conversation, and it's a conversation for another day. We could spend a whole hour just on this particular topic.
Hey, Suzanne?
Yeah.
I've got a question from one of our participants.
Okay.
And they asked, do these statutes still follow the active/inactive case guidelines for the victim to get the report?
So, keeping in mind, anytime that, are you talking about the access to the report that I'm just talking about, or in general?
I'm not sure. Let me see if I can unmute her so she can ask the question herself.
And I think she has a good question. I think I know where she's going. See you there?
Okay. To the person who asked that question, you want to send me a quick chat clarifying. In the meantime, can we get back to them? And I have a different question.
Okay.
What if someone else asked, what if the report is not saying what the victim reports?
Good question. In those kind of situations, if a victim reports that what was reported was not accurate, then we say we need to go back to that law enforcement agency and make a supplemental report and say what was reflected in there was not what I said, and this is what I said. I can even bring somebody else who was there. Let's say that the report didn't include the witness statements who were also there. We bring those witnesses and say we are ready to make a supplemental report about what happened. We have additional information to provide to this investigator about what happened this night. And if they face resistance, then we say, well, let's go chain of command. If the victim says that this did not accurately say what I said, push it forward. Within the age of, most interviews should be audio taped. Once in a while you get the summary of that audio tape isn't quite accurate, then you say, go listen to the audio tape to see exactly what I said. We're going to be entering a new world with body cams. That's going to change that kind of problem as well. But basically going back and saying, let's write a supplemental report. Let's go back to that law enforcement agency. And sometimes they're very resistant, saying, that's done, we've gone by, we're past that, and we're moving on. And you might have some resistance when you try to do that.
That's great, thanks. The person who asked the original question clarified by saying yes to the two statutes that were just read about victims and advocates receiving the police report for free. Does a case need to be inactive for that to be true, or can the victim/advocate receive DV reports while the case is active?
Excellent question, and that focuses in on what do we mean by the report. So we have a statute that says law enforcement must write a report, and we have some jurisdictions who say, okay, I'll just give you the public portion, and that will satisfy this requirement. Where we have other jurisdictions will say, I'll give you the whole thing, the whole investigative report, even while it's still confidential. So do I have a clear answer for you? No, we have different interpretations of what the report is. At a minimum, they should be getting whatever is in the public portion of the report. At a maximum, they might be getting the whole investigative report because that's the arrangement that they have with their local law enforcement agency who is interpreting it in that way, which I think is perfectly reasonable, but that's my personal opinion. So, great question. All right, moving on, some other data issues. Some juvenile offenders. This comes up periodically, thinking that, victims don't get to know anything about juvenile cases, which is completely untrue. Victims of crimes committed by juvenile offenders have the same crime victim rights as victims of offenders who are an adult. And we have special provisions about how those victims can get access to data about the juvenile offense, the delinquency case. The first statute I'm putting up is just about the fact that a victim can find out about the charges in the case, that they get to find out about the name and age of the juvenile, the act for which the juvenile was petitioned, and the disposition of that. So they get to know that the case exists and how it was resolved and who did it. So that's, they have access to this data. Again, there's always this qualifier, unless the prosecutor thinks that they are trying to get this data in order to do bad things, to engage in unlawful activities. The second provision related to juveniles has to do with the law enforcement data. And so a victim can request to the prosecutor that the law enforcement agency release that that investigative data that's been collected and have an avenue of getting that quote, police report. Again, they won't release it if they think that the requester is going to do bad things, that it's going to interfere with the investigation, or that it's otherwise prohibited. All right, non-disclosure. Okay, we're going to talk a little bit about some prosecution protections. First off, that there are two provisions about what victims can assert during a prosecution. The first one is that the victim's home and employment address and date of birth may be withheld from the defendant, but in order for that to happen, the prosecutor has to file a motion prior to that being shared. And so if the victim doesn't want their home or employment address or date of birth to be shared with the defendant or defense attorney, they have to act quickly and contact the prosecutor and say, do not share it, and then it's up to the prosecutor to take steps to file a motion to make sure that doesn't happen. The second one has to do in the context of an actual court hearing where a victim or witness should not be compelled to disclose their home, work address, telephone number, date of birth on the record unless the court finds that it's relevant. But again, this is something that the prosecutor needs to be prepared with in advance so that they're not dealing with it in the moment. If the victim doesn't want this to happen, they should be talking with the prosecutor saying, I don't want anybody to know my date of birth. The prosecutor can be prepared to assert this particular right on behalf of the victim. During prosecution, you'll also see that victims' records get subpoenaed, and those are medical, psychological, education. So this is victim data that somebody else is trying to seek during the prosecution, and then to try to prevent that from happening, you can invoke the Data Practices Act, the 611A provisions, and those privacy and relevancy arguments. We know that our coalitions, the Minnesota Coalition for Battered Women, Minnesota Coalition Against Sexual Assault, Standpoint, and the Minnesota Alliance on Crime put together that privacy memo several years ago, still good, that brings up all the arguments for why you should not, why somebody should not be able to access victim records of this kind, and I would just refer you to that privacy menu and those organizations about those arguments. There's also a person who might get subpoenaed to testify, like a medical professional, a therapist, or a victim advocate. Say you were subpoenaed to testify. What can you do to say, I shouldn't have to testify about my client? What you would do is invoke any privileges that you might have. There might be a doctor-client, a psychotherapist, and those counselor privileges, social work, all those. But there's also two privileges that apply specifically to crime victims. One is the sexual assault victim counselor privilege, and the other one is the domestic abuse victim advocate actually is privilege. So let's look at those in turn. Here's the first one under if a person was called to testify, so we're only talking about in the court context, an advocate, a sexual assault victim service provider, a counselor can invoke the privilege saying, you can't force me to disclose any opinion or information received from my victim. Compare that to that other statute we talked about. That was a Data Practices Act protection, whereas this is a privilege that is invoked in the context of a court case. This only applies to sexual assault counselors under a particular definition who work in a crisis center devoted to providing services to sexual assault victims. And then with domestic abuse victims, there's the victim advocate privilege that they also cannot be compelled to disclose any opinion or information received from or about the victim without the consent of the victim. This is a qualified privilege that the court is going to balance the needs of the victim and the victim service provider with the needs at trial and the need for that information. It only applies if they're called to testify, and it only applies to advocates working in a shelter or program eligible to receive grants from OJP for domestic abuse. Post-conviction, just a couple things there's some data on offenders that victims have a right, and anyone has a right because it's public data. You get to know conditions of supervision or probation, the name of the supervising agent, and the extent to which the offender is complying with the conditions. And while incarcerated, you get to know the location of the offender, and for domestic abuse victims with underqualified offenses, you get to know the offender's zip code upon release. All right, I'm actually running out of time, so I'm just going to quickly wrap it up. Just want to say that we know that victims are anxious for data about the what happens in their community, how many arrests are made in their community, how many convictions, how many cases get reviewed by your prosecutor, how many get declined. Everybody wants this kind of data. Unfortunately, it's not easily attainable. And one of the reasons is, especially for DV data, that a lot of our DV offenses are not identified as such in our statutes. You might have assault that could be a DV-related assault or not. You could have homicide that might be DV-related or not. You could have stalking that might be DV-related or not. So we have lots of criminal statutes that we don't know whether it's a DV case or not. Some clearly are, many clearly are not. There's no one system in our state that clearly tracks a case from law enforcement response through prosecutor review, through prosecution, through case disposition, and onward. We don't have a tracking method to see what happens from the initiation of a case to the end. And we know that our law enforcement agencies, some do track well domestic abuse responses and keep statistics, but not all law enforcement agencies have those kind of tracking systems, and they aren't all the same as each other. They all might have very different ways in terms of how they're tracking domestic violence cases. And then with domestic abuse also and other types of crimes, not all prosecutors track their review decisions. So they can't tell you, I had 52 sexual assault cases that came to my attention this year, came before me to review, and I charged 5. They might not be able to pull those statistics up because they're not tracking those statistics. So with regard to summary data on DV, the long answer, here's a report. I will refer you to that. But I do want to just touch on the fact that there is some other places to look for data. Here's a new one from the Bureau of Justice Statistics about police response to domestic violence, a good source of data overall about DV data. And then there's a new source on the OJP website, our criminal justice dashboards, where there's one place where you can go to look at arrest information, court charges, probation, supervision, and state prison. It might not have the detail that you want in terms of, gee, I want to know how many people got charged with assault 5th degree fear in Fillmore County. They might not be able to give you that, but they are going to give you more information, or at least it's all in one place, to find criminal charging information about arrests and court charges and probation in your county. So you can get down to county and drill down to your county and get information about what's happening arrest-wise. That's going to be UCR response data. Charging-wise, that's your Minnesota Judicial Branch data. Supervision, that's your S3 if you're familiar with that, and then our who's incarcerated. And then finally, the Judicial Branch itself has their own set of dashboards. I will refer you to them where you can look again at county-specific data. You know, a lot of this information was found elsewhere over the years, but now we have these 2 locations where you can get there. You're writing your grant, you want to know the rate of crime in your county. You can get some county-specific data pretty quickly. And with that, I'm going to say, end my presentation. I know I had a couple of questions about defense attorneys. If Danielle, if you could read that to me, I can't quite read the whole question. Danielle? Danielle, can you hear me? Anybody else, can you hear me? No. Yep, I saw somebody raise their hand. Okay, that's great.
Okay. Can you hear me, Suzanne?
Yes, I can.
Okay, I have no idea what is going on with this. I apologize to you so much, Suzanne. Suzanne, those questions about defense attorneys I think were sent directly to you because I can't see them.
And I can't see the whole question, but it seems like there's a question about when defense attorneys receive disclosures and the witness, and I didn't quite get the rest of that. The defense attorney, I'm going to kind of guess, the defense attorney gets data about the victim. I'm hearing feedback now. They get data about the victim through the police reports that because of discovery, if a crime is charged, the prosecutor has to share the police report with the defense attorney and the defendant, and they will get victim data through those disclosures, through discovery disclosures.
Okay, that's great, Suzanne. If anyone else has a question, you want to send it right now and send it to all attendees so we can all see it, or at least send it to the presenters.
All right, well, thank you for the few that hung out to the bitter end. I appreciate your attention. I'm sorry for the speeding through.
Suzanne?
Yeah.
Can I ask a question? I'm not quick enough to type.
Okay.
The question is this. If we have, we're working with a homicide survivor family, and the homicide's been out there for, say, 15 years. We know it'll never get charged because we just know that. Yet the police departments are unwilling to give the police reports because they say it's still open. Is there any remedy for that?
Then you could start going, well, have you talked to the prosecutor? Because really it's up to the prosecutor. They get to make the call. And is it a large office or small office?
It's a large office.
I would go to the victim witness unit and just say, this is what we want to do. We want to approach it, do it formally, write a letter saying, you know, I'm relying on this particular statute to be able to see the police report or a part of the police report that's appropriate, you know. So it doesn't necessarily have to be an all or nothing. You can say, we are just interested in this piece or whatever. And, or you might just, yeah, if there's some particular things that you want to know about. And ask the prosecutor.
There's no statutes covering that at all. Actually, you're speaking to someone who's in victim witness who's in Hennepin County.
Oh. So the question is, can you give it to them? Yeah. Do you have to give it to them? Well, if you decide that it would interfere with the investigation, then you have the ability to say, no, we think it's going to interfere with the investigation. If you think that there's some things that you could share that would not interfere with the investigation and might appease that family, you know, if they just have curiosity about something, or they want to just know who is assigned to this and how many hours did they put in? Did they really work hard on this? You know, what is it that they're trying to achieve by getting the report? And maybe you can provide summary information that won't, you know, harm the investigation, that would make them feel satisfied that they're getting something.
Okay, thank you.
And then, of course, what they can do is they can go the route of filing an action in court and trying to break that, you know, the confidentiality and say that they have a right, you know, right to, or make the arguments that they have about there's a need to allow them to see this.
Great, thank you. That helps.
Other questions? All right. Well, thank you for your attention. And certainly, if other follow-up questions come up, feel free to zip me an email.
Thanks so much.
And thanks to everyone. I want to thank Suzanne very, very deeply and humbly for being a trooper and dealing with the technical stuff, and then just also for sharing her wonderful expertise. I can't even tell you how much Suzanne has done for Mac. It's a lot. It would take another hour. I want to thank all of you for joining us today for the webinar. To let you know, I sent a message about this, but you will all get an email with a link to download a PDF version of Suzanne's presentation. I know several of you were wondering. And to let our MAC members know that within a couple of days, this webinar will be archived in its recorded version, and it will be in the members section of the MAC website, so you'll be able to share the full webinar with any of your colleagues. Also, please take your time to complete the post-webinar survey. Otherwise, thank you so much for joining us, and have a great day. Bye-bye.
Thank you.